I'm Jonathan Turner. I represent the appellate David Paul. I'll reserve 5 minutes
Okay.
for rebuttal. This is a DUI case out of Williamson County. The offense occurred on July 3rd, 2022. The issue on appeal is pretty simple, whether or not the initial seizure was legal or not of the appellant. I'll just review the facts. Facts aren't that complicated. During the suppression hearing, the state called one witness, Officer Jared Anderson of the Franklin Police Department. He testified that he received a BOLO of a citizen reported a potential drunk driver traveling on Murfreesboro Road going east, I believe. And he then proceeded to go that route, and then he received another one that one of the individual was at the Wendy's parking lot. So he proceeds to go to the Wendy's parking lot. When he gets to the Wendy's parking lot, the appellant is there in his vehicle, and 2 other officers are there already with their lights on. During the suppression hearing, after that, he does a DUI investigation and ends up arresting the appellant, David Paul, for DUI. What the state did not present was any evidence of the initial seizure of the appellant, David Paul, at the suppression hearing. It was completely missing. They didn't call any of the witnesses that actually had the lights on and actually did whatever to either lights or got him somewhere else and seized him. That evidence is just completely missing. That those witnesses were not called. The judge findings of law was that even though those witnesses didn't testify, that was enough to find that Officer Jared Anderson had reasonable suspicion to stop the appellant, David Paul. The problem with that...
He'd already been stopped by that point, though. Is that right? He'd already been seized?
Yes, and I think the case law is pretty clear that the time of seizure is either when you're seized physically or when the lights are on. Well, obviously it happened before because the emergency lights of the 2 officers are already on.
You can see that on the video, it sounds like. Or see that on the video. What about like with, you say there's no evidence of it. Didn't Officer Anderson testify that the other officers also received the BOLO?
I objected and said that they can't testify to like what they received. There's no evidence because they didn't testify.
And the trial court sustained the objection on hearsay grounds, but then used it in his rationale. So does that mean the trial court reconsidered its rationale or its earlier ruling?
I believe the rationale is not correct because even though, first of all, we don't know what was the circumstances surrounding the seizure of the initial the officers. They said that they seized them at the Wendy's, but we don't know what BOLO they received or if they received any BOLO prior to that. The Officer Jared Anderson would have no way of knowing that. He just can testify what he heard over the radio. He can't say what those witnesses heard. They could have seized them in the Wendy's parking lot or in the Wendy's itself and not even received a first or second BOLO. There's really no evidence to say what happened, to be honest.
How do you distinguish Hanning? Hanning is the case that the state travels principally on. How do you distinguish Hanning from this situation?
Well, in Haney, that's the truck driver case where he's reckless driving. I think that when you look at the rationale of that case, there's 2 things. They make an important distinction that on that case, the truck driver, they believe the truck driver, they said of importance is that it's almost like a ticking time bomb. The danger of the 18-wheeler driving recklessly, it gives rise to the immediate action that was necessary.
Well, that seems to favor the state here in a suspected DUI. So it's interesting to me. I have no idea why the state at the suppression hearing didn't introduce the contents of the initial 911 call. It's in their brief, but it wasn't introduced at the suppression hearing. But it seems to me that rationale would support the state because, I mean, even going back as far as Downey in the late 90s with the Supreme Court characterized DUI as a swath of death across the state. I mean, if it's a suspected DUI, I would think that would weigh in favor here under Hanning's rationale. Which is more than reckless driving, I would imagine. I mean, it has parts of reckless driving, but it also has impairment too.
I don't disagree that Haney, it does stand for that. I would just differentiated on the facts, and also this case really isn't like Haney, because Haney was where they received a bolo and then he sees a truck on the side of the road and, you know, it's on the same road. The original bolo and where the officer discovered the appellant wasn't even on the road. He wasn't even off that road necessarily. He was in a Wendy's parking lot. I would submit that Haney's facts don't really go with the facts here. But the other thing is, the difference between Haney in this case is Haney pulled up and the officer who got the bolo was the one who seized the person. In this case, the officer that received the bolo wasn't the person who seized the appellant. That's the big problem in this case.
So Officer Anderson didn't get the bolo?
He did get the bolo, but the problem was that by the time he got to the Wendy's parking lot, the appellant was already seized by other officers who never testified during the hearing. And the state has the burden of proving the Fourth Amendment right is not with Officer Jared Anderson or whether he had, the Fourth Amendment right is with the appellant David Paul. And it's clear the case law is at the time of seizure, if it's a warrantless seizure, then the state bears the burden of proving that it was a justified stop, and they didn't present anything.
Would you agree that if Officer Anderson had conducted the initial seizure, based on the testimony that he had, the bolo, the 911 call, all that would have been enough for him to seize your client?
I'm not necessarily conceding that, because the bolo that was at the suppression hearing never went into the details of what actually was the description of the vehicle. They never said what make, model, license plate, or any of that information was never given during the suppression hearing.
So oh, okay.
So that's a missing thing. Well, how you evaluate the bolo.
That's why I was a little confused, because, so the 911 call gives all the information, right? Make, model, and then Officer Anderson or another officer sees it at some point in time and fills in some of the gaps or something like that, correct?
Well, the initial bolo at the suppression hearing doesn't give any of that information.
I'm not talking about what was presented at the suppression hearing. I'm asking you, I want clarification of how I understood this. They may have left pieces out at the suppression hearing. I'm not disagreeing with you on that. But it's my understanding, the way I kind of read it, whether it was actually introduced properly or not, or said at the suppression hearing, is they get a 911 call, correct?
Citizen report, yes.
Okay. A citizen report that gives some information about the truck.
Yes, Your Honor.
And then an initial bolo goes out based something on that.
Yes.
Okay. Then, correct me here, is it Officer Anderson or another officer who sees the truck near the Wendy's, but they're going in the opposite directions or something like that?
So we don't know what the officers that seized him, where they.
I'm not talking about the officer sees him, but I thought there was testimony that someone else saw him or saw the truck, not at the Wendy's, but near where the original call had come, somewhere between where the original call came in and the Wendy's. Someone
You're right.
saw the truck
There's a second
in
call.
the area. Yes.
Yes,
Okay.
there's a second call.
That
There's two calls.
Right. That has more information about the vehicle.
I don't know about that.
Okay.
I'm not sure about that, because when I read the record, it doesn't go into that. It just says that the vehicle was spotted at the Wendy's. It doesn't really say what matched him. I mean,
Okay.
what was the reasoning to match? All that's kind of like ambiguous during the hearing.
So if and when, other than him showing up and seeing it with his own eyes, does Officer Anderson know that it's, and I'm going to get it wrong, but a Ford pickup truck with this license plate and blah, blah, blah? How does he get that information? Or did he have that before he showed up?
I don't know. The transcript is nebulous about that. He just says that there was a matching description of the vehicle, but he doesn't specifically say what it was.
Okay.
So,
Okay. If he doesn't testify to that, he doesn't testify. I mean, he describes it after the stop, obviously.
yes.
But he doesn't say in the bolo it said X, Y, and Z.
The bolo, I can read it, the bolo, that helps.
that's,
But you're reading the BOLO from something other than the suppression record, right?
No, just a suppression.
Okay.
Dispatch told all officers of the radio the description of the vehicle as described by the caller, the direction of travel, and that the caller believed that somebody may be driving drunk. He then responded, and this goes to the second part. Immediately prior to me arriving at Murfreesboro Road, I heard that they had located the described vehicle, my partner, described vehicle with the matching license plate at the Wendy's on that road.
okay.
So that's the two BOLOs that he got. So he received the first one, then he got the second one, which made
And he
the
never
Wendy's.
tested, the BOLO, according to that, the BOLO does, well, the BOLO did say the information, he just doesn't repeat it at the suppression hearing.
And in fact, no one repeats it at the suppression hearing, right? And so, as I understood from the transcript, the state did not call the seizing officer. The state did not call the dispatcher. The state did not call the citizen informant. The state did not call any of the officers who assisted the seizing officer on the scene, and instead relied upon the arresting officer who received the BOLO, did not testify about the contents of the BOLO beyond what you have, didn't testify as to specific and articulable facts of drunk driving, apart from what you read. That's about the sum of it, right?
That's a very fair summary.
But there was testimony that even though we didn't have the license plate number, that the officer said the license plate number matched the
That was the
information
second
he
BOLO
had.
that came out. Yes.
So there is information that there at one point was a license plate number received and that
Yeah.
it matched the vehicle that was stopped at the Wendy's.
Because it sounds like as you read the first BOLO, or his description of the first BOLO, they gave a vehicle description and a license plate in that. He doesn't say what it was, but is that a fair assessment of his testimony?
I would agree that if he's saying it's a matching license plate, somehow at some point in time, there's a license plate
Yeah,
given.
okay.
Now, who gives the license plate?
We don't know.
We don't,
We don't know because it just says it's a matching license plate, but it doesn't say who gave the license plate. We don't know if the officers gave the license plate. I don't know. To be honest, quite
right,
frankly.
because you could read that
Yeah.
as, I'm just making up facts, I admit that, a green pickup truck, and then the second officer said, I just saw a green pickup truck with this license plate, and so he inserted the license plate number into the information.
I don't
And
think
it
that's,
didn't necessarily come from the caller.
I don't think that's ruled out necessarily, Your Honor. I think the problem is there's too much nebulous during the hearing that really, they should have called more witnesses, quite frankly. And
Sounds like you might be correct.
so, if y'all don't have any other questions, I'm just gonna reserve.
Thank you.
Yep.
So this will be the last time you take over a case for a colleague, right?
It's not the first, and I suspect it won't be the last. I'm always happy.
I've been in your shoes, trust me.
Oh, I recall. I'm always happy to pitch hit in these situations. May it please the court, Ben Ball on behalf of the state, as we've established. I'm not Caroline Weldon, but I'm happy to be here today. Here, the trial court properly denied the motion to suppress because the stop of the defendant was supported by reasonable suspicion. Now, I would agree with this court that this is not the most fulsome suppression hearing here.
What's the reasonable suspicion? Because we don't know, in order to establish the reasonable suspicion, do we not need the officer who had the reasonable suspicion to testify what his reasonable suspicion was?
So we don't. I think we have enough information here to get there. Would it be helpful? Absolutely. But as far as the officers who actually conduct the stop, because I agree, it was Officer Anderson did not initiate this.
But we
stop.
don't, I mean, I'm sorry to interrupt you, but I mean, Officer X, since we don't know who it is, I'm gonna call him that, Officer X could have pulled the defendant over because he had a bumper sticker on his truck that Officer X just didn't like, or Officer X was just having a bad day and, he didn't like the way the guy looked and it was a pretextual stop that he had no basis for. We have no idea why he stopped him. None. You can tell me we have all this information out there, but we don't know that Officer X has that information, and we don't know why Officer X pulled him over.
So I would agree that we don't have any direct evidence of that. I would point back to the trial court's ruling when he talks about this, because the trial court, what he says, because this argument is raised at the suppression hearing. We don't have these officers testifying. And the trial court says is I have circumstantial evidence of this, because we have Officer Anderson who testifies about the BOLO. There's dispatch, and he says it goes out to all officers. Now, he obviously can't speak to whether they receive it or not, whether they perceive this, they hear it if they're in the car at the time. But he says it goes out to all the officers.
But he doesn't give the details of the BOLO either.
He does not give an exact description of the BOLO.
Well,
Does he give any description?
He gives a description that is, I would say, just enough. What he says is...
I mean, does it give any more than your friend recounted?
So what he says is that there is a 911 call, dispatch says, where a citizen has reported that there is a drunk driver.
Suspected drunk driver.
Suspected drunk driver, that there's a description of the vehicle. He does not provide that description, but he later does establish that it matches, when the car is found, that it matches, or the truck is found, it matches the description. He says that it was last seen on Murfreesboro Road, traveling east from downtown Franklin to the interstate, which is consistent with where the car is found. When the car is located, there's another call, and it's 2 minutes later. Given this time frame, it's reasonable for the trier of fact here. It's a reasonable inference that these officers who stopped this vehicle received the dispatch that was
How do we
dispatched to
know
all
that?
officers.
How do we know that?
Because it's a reasonable inference. Obviously you don't have direct
How
evidence.
can Officer Anderson testify that every officer heard that BOLO, and us to say, that's right?
To be clear, I'm not saying that he testified that they heard it, and he could not have testified to that. He does not know what their subjective experience is. What he says is
to Judge Greenholt's question earlier to your friend on the other side, the judge sustained the objection. You're right, you can't testify that, but then he uses it in his rationale for allowing the stop.
Well, what the officer testified, in fairness, was not that they heard it, is that the dispatch was sent out to us. So, he knows this is this is a BOLO. It is dispatched to all of the Franklin Police Department. He can't testify to whether they heard it. We can get to that through circumstantial evidence based on the timing and location. And that's what the trial court says. This is a close case. I'm not denying it
Well,
is.
let me make it a little closer, perhaps. Or let me see where it goes.
Sure.
All right, so all of the information you've relied upon so far is relevant to identity. And so that is, we have a suspected drunk driver, but the driver is driving on this road in this location with this license plate. All of that is fine, and all of that is necessary for identity. I wonder, though, what we have by way of a crime. So if an officer came into court and said, I pulled him over upon suspicion of DUI. I had a hunch, I had a suspicion. I think the first thing we would do is ask the officer, what are your specific and articulable facts that gave rise to a reasonable suspicion that there was impaired driving, drunk driving going on? And the officer would either identify the facts or not, and then the case would rise and fall on that. And I don't think there's a lesser standard here necessarily with the BOLO. And so with the BOLO, I think we need to have some facts in the record that show that the citizen informant gave facts such that, specific, reasonable, articulable facts, to show that the suspicion is more than just a mere hunch. We don't know that from the record. Now, I do know what the facts are from the state's pleading. The state didn't prove it up at all, and it's a mystery to me about why it didn't, because it obviously had the facts. So on the record here with the testimony, what are the specific and articulable facts here that give rise to a reasonable suspicion of drunk driving, other than the conclusory statements that there is suspected drunk driving?
So, Your Honor, I agree with you that I think this is actually the closer question here. And during his testimony, Officer Anderson does make a reference to suspected drunk driver. But as I recall, when he's describing the BOLO itself, he says that a citizen has reported a drunk driver. He doesn't say suspected. And I would categorize this sort of similar to this, as being similar to the case we've cited, State v. Hall, where what you have are some citizens informants and who just say, we encountered Mr. Hall he was intoxicated. And that's all we essentially have them say.
If we
and
had
he
that
drove
here,
off in
if
a
we
van.
had that here, that would be fine, right? So if we had the dispatcher who was called, who said, I received from a citizen informant, evidence that, that John Smith was at the Wendy's. John Smith appears to me that he's impaired. He smells of alcohol and he's going to his truck or whatever. I think that's fine, right? And that's what you have in Hall, is you have those specific and articulable facts. Here, we don't have that. We just have the suspicion. And I think if an officer came in and just said, I suspected he was a drunk driver, and gave no facts beyond that, I think we would have a hard time sustaining it under current law.
I think that's right. I would say that I think in Hall that there were fewer, as I recall it, specific facts. As that there was still just an assertion from these motorists that flagged the officer down that the defendant was drunk. Now, what we do have there that we don't have here, I'll acknowledge, is a sort of specific description of how they encountered the defendant. But if I recall in Hall, that I don't know that they gave a litany of reasons why they would have suspected him to be drunk. They just reported that in their experience they believed him to be drunk.
Which is what we don't even have here.
I would disagree with that. We have, the BOLA says that the citizen informant reported that he was driving drunk. Now, later the
And
officer
all of that's
suspected.
hearsay though, right? I mean, all of that is hearsay.
Are you saying that I could call in right now to Metro Davidson County Police Department and say, I just saw, sorry, Tom,
No, you're fine.
Judge Greenholz.
Don't say Judge Greenholz, goodness. But pay that, I
I
understand.
just saw Judge Greenholz, he's drunk and he's driving. And that's enough for Davidson County to go pull him over?
Well, that would obviously be a completely uncredible comment. Given
Right, I understand.
General, thank you very
That's-
much. Thank you, I appreciate that.
Which is why I apologize to him in advance. But, I mean, that's really what you're arguing, is somebody who also, not that I add a lot of credibility to it, but if I said, hey, this is Judge Dyer and I just saw Judge Greenholz and he's drunk and he just got in his car and he's driving, okay, maybe. But you don't even have that. We don't even know who the citizen is, which I know we give them some, but I mean, you have no idea how they're connected. You know nothing of how they know this person is, quote, drunk.
What they observed.
What they observe. You don't have any of that. I mean, I think that's where Judge Greenholz is
There was-
going,
it was
is
the
that,
thought.
yes, you have a statement, and the reason I jumped in is because he keeps saying suspected, and you try to act like the word suspected is not there.
I think it actually is though, but I'll stand
But my
corrected.
point is, either way, does it really matter? Whether the person said suspected, or even if they just said he's drunk, how do they know that? How do we know they know that? Where are the specific and articulable facts that someone knows, or at least had reasonable suspicion to know, that this individual was intoxicated while driving?
So first, I don't disagree that suspected appears in his testimony. What I'm saying is that when it's that appears to be sort of his summary of it when he first says it's Bolo reporting a drunk driver. So I'm not disputing that he does use the word suspected soon after that. And I have to acknowledge that this is pretty sparse on the facts, but I think what we have here, is just maybe a whisper over the line here. So we don't just have I spotted X vehicle with a drunk driver. We do have I would like more description of it, but an indication that there was a description of the vehicle and a license plate, and that those matched up, and not just description of the vehicle, but where it was driving, what direction it was driving.
But again, that goes back to, I mean, I'm going to keep kind of going back to my hypothetical. I can tell you where someone's driving, what kind of car they're in, all those wonderful things. Those things don't give you articulable facts to pull me over or to pull that person over. And me just saying X person is intoxicated, I just don't think that gets you there. You got to have something that the citizen caller had some basis of knowledge as to why the person was intoxicated, and not just they're intoxicated and let me give you all these facts about their car. That doesn't, and where it is, I don't think that gets you there.
I mean, I certainly understand the concern here. I mean, obviously, I would prefer that the record be filled out better here, that the suppression hearing.
Can I add one more level of concern?
Sure.
The BOLO itself, and we keep referring to the BOLO, the suspected drunk driver, or whatnot, but I think, and your friend on the other side will correct me, I thought that was subject to a hearsay objection. I thought that Mr. Turner said, I object to the contents of the BOLO from this officer. And I think the court sustained it And the court said something like, I'm going to consider it for the officer's actions or something like that, or I'm going to consider it for non-substantive purposes. The court refers to it later on, not seeming to understand or recall, and I've done this, I'm not faulting the trial court by any means, perhaps the evidentiary objection, but at the time the evidence comes in, it is subject to a hearsay objection that is sustained. And so if it's not for substantive evidence, then the record doesn't even indicate what the contents of the BOLO were. So we know there was a BOLO, we don't know the contents of it. So what's the response to that?
I do have to acknowledge that when the trial court admitted the evidence, it did say that it was hearsay, and it did say that that it was not taking it for the truth of the matter asserted.
I mean, really doesn't this case just boil down to is that the state had the facts, the state had the proof, the state didn't call its witnesses. And, whether we fault the DA's office, whether we fault whoever, it's like the case was there, but the case just wasn't made. They chose to call one witness, and that witness couldn't sustain it. They had the ability to call the dispatcher, perhaps. Dispatcher wasn't called. They knew who the citizen informant was. They didn't call the citizen informant for whatever reason. They didn't call any of the other officers on the scene. Perhaps they had the ability to do so, and maybe the officers couldn't appear that day. But what happened is they appeared for a hearing with a pretty good brief and just didn't prove what they asserted. Isn't that really what we have here?
Well, I would have to disagree. They didn't ultimately prove what they asserted, but I can't deny that this is that it would have behooved them to put on
Seems like it's
much
just a
more
failure
thorough
of the record. It seems, and we do this sometimes, and this is not to fault anyone in particular, heaven knows, but it seems sometimes we get so wrapped up in our trial practice that we forget to look about how the case is going to look to others who can only review it from a record. And it may be that everyone else in the room knows what's going on, and everyone else in the room knows what the dispatch is, but then when it gets to Nashville, we don't have any idea because it's not in the record. And it seems to me this case is a perfect example of why preservation of the record and building the record and making the record is such an important deal, because it has consequences.
As someone who spends a great deal of time poring over cold records, I'm not going to disagree with that statement that yes, these better developed records would behoove prosecutors in almost any case.
Sure.
And I certainly would have preferred that there be more in this record. However, at the end of the day, it's our position that this was, while close, just enough to provide reasonable suspicion for the stop.
General, thank you.
Thank you.
Thank you, Your Honor.
Any rebuttal? You have time, so.
I'm just going to be brief. I'm not going to be very long. I just, Your Honor, just want to point out with the judge finding of law, he actually agreed with the fact that there was no proof about the reliability of the BOLO, he said specifically that reasons why the original officer detained him, they failed to provide proof about the BOLO, the reliability of the information. He agreed with me that they failed to do that, and then he proceeded to go in the analysis of what Officer Anderson observed. I would just submit that I agree that there was no basis in knowledge. We don't know what they saw, what the drunk driver was. And you look at Florida v. JL of the Supreme Court. In that case, I know it was a frisk, but it still bears some merits. We don't have any idea what this person knows, how they know it, or whatever.
I mean, that's not a BOLO case. I mean, the real, okay, sure.
I agree, Judge.
That's okay, Mr.
I'll leave it at there. Yeah, I hope you grant the appeal. Thank you, Judge.
Thank you.
Thank you, Mr. Thank you.
Before we call the next case, Mr. Ball, I just want to tell you, you did an excellent job. I recall one time I had to pinch hit for someone. It was about a 10-page brief. I read it, no problem. I got up to argue. Our